And to make a request.
And to make a request.
Yeah.
I would like to call the recommending meeting to order now at 9:05 on July 20th. Are we in compliance with the open meeting law?
Yes, ma'am.
Okay. With that being said, I would like to turn the floor over to council to share with us a few words.
Thank you, Councilman Barlow. The first item is any of the bills that are moved out of committee today will be eligible for adoption on August 4th.
Why August 4th?
That's the normal period, unless it's fast-tracked.
Okay.
The second item...
Well, I guess the question I have then is why did you bring it up? When in fact that's the normal process.
A lot of the citizens have noticed that we don't always make an announcement about each bill, and so I just thought it might be good to do it up front.
Okay, great.
Thanks. The second item is we would like to request that item number 8, which is bill number 2010-31, be held in advance a couple of weeks. Mr. Jervik, the city attorney, was planning to make a presentation on that, and he's unavailable today, and so we would ask that the committee consider taking that item first and holding it in advance for 2 weeks.
Okay, and that will make it what date, Angela?
It's recommending will be the 7th, 8/3, sorry, recommending. August 3rd.
Okay, great.
Thank you.
Okay. We will take that into consideration. Anything else? Okay. At this time, we'll move to item number 3 on the agenda, which is bill number 2010-26, which updates the zoning regulation to establish the use of beer and wine cooler cultural establishment, redefine the current use related to private museums and art galleries at Las Vegas Arts District. Staff?
Members of the committee, Flynn Fagg with the Planning Department. This proposed text amendment is to address 3 issues in the Arts District specific to some of the events that they have there and some of their operations. First of all, the addition of beer wine cooler for cultural events allows art galleries to sell beer and wine as part of the cultural events that they have in conjunction with First Friday, and adds that as a special use permit that they would be allowed to obtain. Secondly, relative to art galleries, we're defining art galleries as a retail space. This will help to eliminate some conflicts that we have with the building code currently. And then third is to add the use outdoor events to the Downtown Centennial Plan's list of permitted uses for the Arts District, which eliminates the need for them to obtain a temporary commercial permit each time they have the First Friday events. Again, all 3 of these items are intended to solve some of the issues we have there with the operation of events and related to First Friday in the Arts District, and we would hope for your support of this text amendment.
Okay, thank you. Is there anyone here wishing to speak on this item? If so, please come forward, state your name for the record. Okay. Councilman?
Motion to approve.
All in favor?
Aye.
Aye, so moved. Bill number 2010-27 adopts Symphony Park Design Standards Manual and related design documents, sponsored by Mayor Oscar B. Goodman. Staff?
The proposed changes that you have before you relative to the Symphony Park Design Standards, number 1, the largest change is to change the name of the document. Currently, it's called the Union Park Design Standards Manual. And with the change of the name of the development, we will change that throughout the document itself. There is another substantive change that we are proposing, and that is to allow the Symphony Park Design Review Committee to be able to approve sign waivers in conjunction with the standards that are listed there in the document. The remainder of the changes are relatively minor in nature and essentially update or clarify some of the standards that we have currently, and
Right.
we would request approval.
Okay, thank you. Is there anyone wishing to speak on this item? Please come forward. State your name for the record. Seeing none. Councilman?
Motion to approve.
All in favor?
Aye.
Aye, so moved. Bill number 2010-28 adopts safety and seismic safety elements of the Las Vegas 2020 Master Plan. Staff?
Flynn Fagg with the Planning Department yet again. This is an update to the safety and seismic safety element. It was originally adopted in 2001. And what we're doing is making updates that address some of the changes that have occurred to NRS and then also updating it to current city practices. Some of the major things that we've done here with the element is we've removed a couple of sections that aren't required by NRS. We have also received the assistance of Fire and Rescue in updating the fire hazard safety chapter, and Public Works has contributed to the drainage and flood control chapter. And with those changes, we would request that the element be updated.
Okay. Anyone wishing to speak on this item, please come forward, state your name for the record. Seeing none. Councilman?
Motion to approve.
All in favor?
Aye.
Aye, so moved. Bill number 2010-29 adopts the Historic Properties and Neighborhood Preservation Plan element of the Las Vegas 2020 Master Plan. Staff?
Flint Fag with the Planning Department again. This is to address two changes that occurred relative to the 2009 legislature session. Number one, it requires us to add language relative to the protection and preservation of paleontological sites. And then secondly, it requires us to add a definition for historic neighborhoods. And so basically the changes are necessitated by changes to NRS made by the legislature in the last session.
And this is in reference to the Ice Age Park in the Northwest?
It's not specifically to the Ice Age Park, but it does facilitate that request, yes.
Okay, great. And speak to the historic neighborhood element.
Essentially, Assembly Bill 304 requires us to add a definition for historic neighborhoods. And what we are doing is adding the definition that was proposed by the bill, that essentially any neighborhood that's older than 50 years or the bulk of the structures are older than 50 years old may qualify for historic designation. And so we're adding the definition as proposed by AB 304.
Thank you. Is there anyone here wishing to speak on this item? If so, please come forward, state your name for the record. Seeing none. Councilman?
Motion to approve.
All in favor?
Aye.
Aye, so moved. Bill number 2010-30 revises and updates Chapter 14.17 of the Municipal Code relating to wastewater collection and treatment. Staff?
Good morning. Jorge Cervantes, Department of Public Works. This is an update to our municipal code as it relates to wastewater. This code hasn't been updated since 1994. There's been changes in federal regulations as it pertains to the treatment of wastewater and stormwater. So this will bring it within conformance of the federal codes and also provide some flexibility in the code. Dan Fisher with the Environmental Division is here, and he'll point out some of the major changes to the code.
Thank you.
Dan Fisher, Environmental Division. There's the changes update some language that were necessary to meet with federal law. Changes have been made with the federal regulations since 1994. It removes any references to stormwater quality, which now we have a separate ordinance for that, 14.18, and it gives us some more flexibility to regulate the industries. It allows groundwater to be discharged into the sanitary sewer when it makes sense to do that. It takes away some requirements for monitoring that are expensive and difficult to do. What it doesn't do, there's no changes in fees in the new ordinance. The fees are in a separate resolution, so it doesn't increase any of the burdens on the industries. We've talked to the regulated community, and there doesn't appear to be any opposition to what we proposed.
Okay. Is there anyone here wishing to speak on this item? If so, please come forward and state your name for the record. Seeing none. Councilman?
Motion to approve.
All in favor?
Aye.
So moved.
Thank you.
Thank you all. Bill number 2010-31 updates the regulation governing certain commercial, entertainment, and solicitation activities within the pedestrian mall. And this bill is proposed by City Attorney Bradford Jervik. Is there anyone here from the public wishing to speak on this item? If so, please come forward and state your name for the record.
This is Alan Lichtenstein from East Nevada. I don't know if you were holding this in advance or...
Can I have, I'm sorry, Councilman.
I'm sorry, would you come to the microphone? I'm sorry, sir.
Alan Lichtenstein from the ACLU of Nevada. I think this is the item that you wanted to hold in advance, then be happy to hold my comments, but...
Well, what I wanted to do is provide anyone from the public an opportunity to speak on the item prior to the council taking into consideration whether or not we're going to hold it or not. So I wanted to at least provide the public an opportunity to speak on the item before we made a decision.
Okay, that's fine. I have some written testimony that I'd like to hand out.
Submit it to the clerk, please.
Kind of copies of this to... what the written testimony will reflect, and in fact the judicial record will reflect, these are items that we have litigated with the city and the Fremont Street experience since 1997. Much of this is stuff that, frankly, is kind of amazing to me because the courts have already ruled on a ban on advertising, restrictions on leafleting. I mean, the city has spent probably six figures in attorney's fees alone on these. We're in the process now of actually, under the guidance of Judge Levitt, pursuant to a court case that the same court case that had been filed, in negotiating with the city attorney's office, as well as the Fremont Street experience, to come up with guidelines that will fit within what the Ninth Circuit and U.S. District Court have said are the constitutional parameters, and yet have reasonable regulations. This would pretty much kill it. This would bring us back to 1997, and I wouldn't say we would start all over again because, again, the fact that it's a public forum, the fact that leafleting has to be allowed, not just in free speech areas, but on it like on any street or sidewalk. The fact that there can be tabling for First Amendment activity, all sorts of things. The document mentions the Berger case from the Ninth Circuit, which wasn't our case, but had to do with street performers in Seattle. It was, I believe, last year that it was decided. So I guess the city has a choice. The city can either work with us and other stakeholders involved, and people we represent, to work within the parameters of the courts, or we can go back to court again. And I can tell you that Judge Ezra, at the last time he ruled against the city, said, I don't want to see these things keep coming up again, rehashing the same particular issues, which is why when we discovered that this particular ordinance that's going to step backwards was introduced, we were kind of surprised. We are going to go ahead, again, under the auspices of Judge Levitt, and continue to try to work something out. And I would just certainly hope that the city, for whatever reasons, doesn't go down the road it's gone down so many times before in the last 13 years and decide to pass whatever it wants to pass, even though the courts have said you can't do that, which is essentially what you got here. And again, it's spelled out to some extent within the document. It's certainly spelled out within all of the court documents from both the U.S. District Court and the Ninth Circuit, and we've been up there 3 times to the Ninth Circuit. This would be Fremont 4, I guess. At some point, I think the city is going to have to understand that those judicial rulings mean something and have to be adhered to, and try to work within that particular framework. This particular proposed ordinance doesn't do that. It sort of goes back to 1997, and I wouldn't think that anyone wants to redo that one again, but again, if necessary, we're prepared to refight the same battles over again.
Mr.
Lichtenstein, yes.
Lichtenstein, help me understand your comment as it relates to going back to 19...
The regulations that are proposed here, most of them, are things that existed in previous ordinances that were struck down by the courts.
Okay.
Going back to when we first started litigating this case.
And what year was this?
1997.
1997.
And over the years, the courts, both the Federal District and the U.S. Court of Appeals for the Ninth Circuit, have said, and I'm just sort of cherry-picking here because I want to go through the whole list, the city cannot ban leafleting or restrict leafleting. Now, it can restrict assault or obstruction or things like that, but it can't say, well, you're only allowed to hand out leaflets here, you're only allowed to have demonstrations here, you're only allowed, and there's still a restriction on mall advertising within the mall, that it can only be controlled and approved by the Fremont Street Limited Liability Company. And recently, within the last couple of years, Judge Ezra in the U.S. District Court said authoritatively, no, that is a First Amendment protected activity. Putting up tables for First Amendment activity. Again, both the Court of Appeals and the U.S. District Court. In terms of street performers, this wasn't even our case, this was the Berger case out of Seattle, said you can't require them, and when I say street performers, I'm not talking about people who are charging, but people who will just go out there and play their guitar or actually look like Elvis, not that that would ever happen in Las Vegas, and have people take pictures with them and give them tips. Again, all of this is well-trod territory, and to pretend that none of this litigation has taken place, that none of these court decisions have taken place. We have people here, I'm looking around the room, from the press, and I know what they're going to do. They're going to go back through the archives of their old stories, and they're going to get a large stack of them, because this is nothing new. Again, we are in the process of dealing with negotiations through Judge Levitt of the magistrate, Judge Levitt of the U.S. District Court. We've gone back and forth. Actually, I think we've gotten pretty close. I think that a few more meetings and we may be able to have regulations that will work for everybody, which is why this particular one came like a lightning strike out of the blue, because that would sort of kill all the progress that's been made.
Who have you been working with?
The city attorney's office, mostly has been Mr. Urbeck, and the lawyers for the limited liability company, Todd Bice and Patrick Riley. And again, this has been ongoing settlement conferences. I can tell you that we're doing it. I can't really talk about the details of it because that would require going through the lawyers, and I can't talk directly about it, but certainly the fact that we are involved in settlement conferences, and I can give my opinion. I think they're going well. I think that we've made a lot of progress. To kill that and then just relitigate the same issues that aren't even issues anymore just makes no sense, and I don't even think it makes sense politically, because I think the public is tired of seeing the same things over and over again, and the city spending taxpayer money to fight battles that the Constitution says can't be done. So I would strongly suggest looking very carefully and saying maybe we ought to hold off on going down this road yet one more time. Answer any questions if any of you have them.
I appreciate it. Thank you.
Thank you.
Is there anyone else here wishing to speak on this item? If so, please come forward and state your name for the record.
Hello, my name is Jeff Victor. My name is Jeff Victor. I'm the president of the Fremont Street Experience, LLC. To be clear, I'm not a lawyer, but I have been sitting through a number of these proceedings over the last 4 years. And Judge Ezra did, in fact, say that he was tired of seeing this in court. The same arguments being made by both sides is something that he's tired of and the courts are tired of. What he asked, very specifically, is that we get together with the ACLU and find some middle ground. And we have been doing that for over a year now. I differ from Mr. Lichtenstein's opinion on the progress we've made. We've found zero movement on behalf of the ACLU. They have no motivation to come to center on this and have no interest, it would appear, in coming towards center on this. And so what the public is and should be tired of is being harassed openly on the street by people conducting commercial activities in what is clearly a tourist recreation area. And so what we're proposing is a time, place, and manner argument that has been employed in numerous districts similar to the Fremont Street Experience. And it's just a way of regulating the activities with while also allowing the ability for these kind of activities to take place. And And so we hope that the council will support and understand the true nature of this. There's a very big difference in my mind between free speech and commercial activity. And in either case, again, whether it be airports or pedestrian malls or other public forums, time, place, and manner arguments are well-tried and very successful and have worked to the betterment of both the folks trying to engage in the activity and the public that is surrounded by it.
Where, Mr. Victor, can you point to where the time, place, and manner has worked effectively and/or efficiently for the betterment of business and those individuals who seek to entertain on the street?
In the 3rd Street Promenade, down in the San Diego area, the street is laid out quite a bit differently than it is here on Fremont Street. The commercial activity generally happens on the sidewalks of the pedestrian mall. In the center, which is an abandoned street, street entertainers and others are allowed to perform, but they regulate the way it's done. So there's a time that it's allowed, there's a specific place that it's allowed, there's a manner in which it's allowed. The acts have to rotate every couple of hours so that there's no squatting on favored spaces and so on and so forth. It's been done in airports like the San Francisco airport where there are 3 speech zones where if you want to spread your message, you can do so behind a counter. We're not allowed to step in front of or otherwise harass the flow of traffic that's there to take advantage of what the airport is originally intended to do. There are many other examples. Again, I'm not a lawyer. I don't have case studies in front of me. But I believe if Brad Jerbick were here or one of our counsel were here, you'd hear in detail, places throughout the United States, including those that fall within the Ninth Circuit, who have found great success with this.
Okay. Thank you, sir. If there is anyone else here willing to speak on this item, please come forward, state your name for the record. Seeing none. Councilman?
Well, I was hoping to have a nice discussion this morning about this and listen to, but he's not available, you said,
That's
correct?
correct.
So I apologize for both of you coming down, and but apparently we're going to obey, you want to obey this till the next recommended committee? Is that correct?
That will be August 3rd, Councilman.
August 3rd, okay.
If I could just, if you'd like to see the Santa Monica ordinance itself, I've got
Sure.
copies. I didn't make copies for everybody, but I'm more than
Okay, if
happy
you just give it to the clerk.
and you can make your own comparisons.
And just state your name for the record once again, as far as
Alan Lichtenstein
distribution.
from the ACLU of Nevada, and I'm just giving a copy of the Santa Monica ordinance that was referred to allow you to make your own comparisons.
Thank you.
So I would hope that both of you would be available to come back to the next recommending committee, because I'd like to hear the discussion, the presentation from Mr. Jerbick, and I'd definitely like to hear it from both of you after he's done with the presentation. So with that, I'll make a motion to obey this to the next recommending committee.
That will be August 3rd, Councilman?
Yes, sir.
Okay. All in favor?
Aye.
Aye. So moved. So bill number 2010-31 will be in abeyance until August 3rd. We're now down to citizens' participation, and public comment during this portion of the agenda is limited to matters within the jurisdiction of the committee. Anyone here wishing to speak on this item, please come forward and state your name for the record. Seeing none, Councilman?
Motion to adjourn.
All in favor?
Aye.
So moved. Thank you.